The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to all those who are watching on our Supreme Court Live channel. Mr. Shima, I would ask at this point that Mr. Shima, the clerk of the appellate court, would call our docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, March 31st, 2021 consists of one case. Appeal number 121328, City of Shawnee versus Asnake H. Adem. Johnson County briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Richard Klein on behalf of Asnake Adem, the appellant and defendant in this case, Your Honor.
Good morning. May it please the court, Assistant City Attorney Jenny Smith on behalf of the City of Shawnee appellee.
Thank you, counsel. Mr. Klein, you may begin your argument.
Thank you, Your Honor. In April 2017, Mr. Adem was a taxi driver. He picked up early that morning, he picked up a passenger, female in Westport, Missouri, and took her to Shawnee, Kansas. On the way to Shawnee, at one point, he stopped his taxi, according to the victim, and asked her to sit in the front passenger seat. He then stopped 2 more times, put his hand on her leg at least once, and hugged her a number of times before dropping her off in Shawnee. He was convicted in municipal court of sexual battery. He appealed that and then was again convicted in district court of sexual battery. And at sentencing, the judge ordered him to register as a sexual offender. The sole issue on appeal is whether a municipal court conviction triggers the Kansas Offender Registration Act for registration as a sexual offender. And our argument is it does not. I think the first point I'd like to make is that in our view, the Kansas Code of Criminal Procedure controls municipal convictions, and there's no requirement in the Kansas Criminal Code of Criminal Procedure for a conviction in a municipal case. And in fact, it seems to exclude the requirement that the Kansas Offender Registration Act would be triggered. KSA 22-2102 states that the provisions of the code in municipal cases are only specifically done when it's provided by law. And our argument is that nowhere in the Kansas Code of Criminal Procedure, nor in the Kansas Offender Registration Act does it specifically say that a municipal conviction triggers the requirement for registration.
Counsel, my first question is right to that point about the language of 2102. Is the obligation to register something that happens in a municipal court proceeding? I understand that there was an order made by a judge, but we've said previously that the obligation to register is a springing obligation that operates as a function of law, which seems to me to undermine your claim that the obligation to register actually arose in a municipal court proceeding.
I think the question there is going to become is, how do you take municipal court proceedings? They're not courts of record. There are differing levels of professionalism across the state on how municipal courts are handled, and I don't want to criticize any municipal court or any municipal court judge, but the judges don't have to be attorneys even in municipal court. It's a totally different, a necessary part of the courts in Kansas, but they're just handled differently. As I briefed, I'll say it again. There's a huge difference in district court in Johnson County and in night court in Bonner Springs or DeSoto, Kansas. There just is. It's a reality, and you can't get past that reality and say that the convictions are the same. And I understand. So, but I'll go back. That's probably not answering your question. You're saying that CORA. I understand that argument that CORA applies, but it seems like in the Kansas Criminal Code it says that you can only do something in a municipal conviction if it's specified by law. So even if we
it talks about municipal proceedings, not municipal convictions. So I guess I can rephrase my question to just ask you, what's your best argument for how CORA has been applied in a municipal court proceeding?
I don't think it is applied in municipal court proceedings. I don't think anybody.
Well, your argument is that, in fact, the state has, in fact, applied CORA in a municipal court proceeding, and that is disallowed by 22-2102. That's how I understand your argument.
Yes, and that's the start point. And if
I'm asking you to the predicate question, even if I assume that you're right, that 22-2102 does in fact preclude the application of CORA to a proceeding in municipal court. I'm asking you to make the best argument for how did that did that even happen? Was CORA applied in a municipal court proceeding?
Yes, because the judge ordered Mr. Adem to register.
And we have case law that suggests that what the judge said is irrelevant because the obligation to register springs by operation of law.
I understand. But the judge still did it. He would never have registered if the judge didn't tell him to.
Do we need to overrule that precedent about the springing obligation in order to rule in your favor?
No, I don't believe so, Your Honor. I think one, that you can rely on 22-2102. And I think you can rely on the legislative intent with municipal proceedings. The legislator had the opportunity to add municipal proceedings in 2012 in HB 2568, and the original draft had municipal proceedings in it, and they took it out and left the rest of the language the same. I think it's easy to look at that and say the legislator has never intended for municipal proceedings to require registration or municipal convictions. And I think if you look at the federal Sex Offender Registration Notification Act, I think that kind of backs it up. That specifically does not include municipal convictions. And, I think it's pretty easy to follow that the legislator just followed what the federal law required.
And so the way you are interpreting this, when it refers to no application in proceedings in police or municipal courts, that includes actions that are actually being tried on appeal in district courts.
Oh, absolutely. I don't think the district court, Your Honor, I don't think the district court can do anything that a municipal court could not do. And I think the case law is pretty clear on that.
So the interesting textual distinction, I think, and which may be meaningless, but that 22-2102 refers to courts, not actions. So it doesn't refer to a municipal action, or a municipal complaint or citation or whatever, but to courts. So that's the textual reason for my question. But I suspect that doesn't change your answer. Is that right?
It does not, Your Honor. And Your Honor, if there are no more questions, I don't have anything to add.
Let me just ask you, you're not contesting that a sexual battery under the municipal code violation, or however you phrase that, is comparable to the sexual battery offense under Chapter 21, are you? They're comparable, they're the same in terms of what is required for the city or the state to prove?
The elements are the same. Yes, Your Honor. The elements are exactly the same in this case. So again,
Is it your suggestion that 224902, or were you moving on to that argument? About the comparability of the offense under Cora?
The elements are the same. But the fact of the matter is the convictions are different. It's to me, you know, I who practices in these courts, there is, and I'm not suggesting that the Shawnee court is unprofessional or anything else. There is a huge difference in how in the procedures in district court and the procedures in municipal court. There just is. There's a difference between going in front of a district court judge at 9 a.m. and standing in front of a Bonner Springs judge at 8:30 at night. They're just, the reality is they're different.
But is it your suggestion that that 224902 B7, that comparability is that statute has ambiguity in it?
No. Well, yes, I am. When it comes to municipal courts, yes, because I think the legislator, if they intended municipal court convictions there, they would have said that it includes municipal courts, and they didn't.
So what component or what part of the statute, what language does that ambiguity arise from? Convicted of an offense, or what language?
I think it is convicted, yes.
Okay.
Because again, the legislator had the opportunity, considered this and then didn't do it. And I think even when you just look at convicted, the convictions are different.
Are there any other questions? Mr. Klein, any more to add, summarize?
No, Your Honor, thank you.
Okay, thank you. Ms. Smith?
Thank you, Your Honor. May it please the court. I think if the court looks at the plain language of the Kansas Offender Registration Act, you can see that there are 3 times in the Kansas Offender Registration Act where it's specifically authorized by law that municipal court convictions trigger the requirement of registration under Cora. Those 3 areas are KSA 224902, B5, B7, and T. So we're talking about the definitions of a sex offender. B5 talks about someone who has been convicted of sexual battery. The appellant in this case was, convicted of sexual battery as defined in state statute. In this case, Mr. Adem, the appellant, was convicted of sexual battery as defined in state statute. B7 says anybody who's convicted of a comparable offense to the state statute offenses listed above. The appellant was convicted of a comparable offense of sexual battery as listed in B5. And then again in section T, it talks about specific instances where Cora was never intended to apply. Municipal court convictions are not listed there. I want to start my argument talking about subsection B5. In subsection B5, it says anybody who is convicted of sexual battery as defined in state statute. The city of Shawnee adopts the Uniform Public Offense Code. In the UPOC, we define sexual battery the same exact way as the state statutes define it. Because Mr. Adem, the appellant, was convicted as defined in KSA 215505A, the city's position is that he was convicted of sexual battery as defined in state statute. And so his duty to register is triggered under B5.
Ms. Smith, let me ask you though, because UPOC in the editor's note at 3.2.1 states that because municipal courts are not courts of record, a conviction under UPOC 3.2.1 for sexual battery does not trigger KORA registration.
Thank you, Justice, for that question. With all due respect to the league who writes the UPOC for us, I don't think the league can dictate when KORA applies and when KORA does not apply. That would be like the league saying on a DUI ordinance or a driving while suspended ordinance that the Department of Revenue has no jurisdiction to suspend someone's license. The league cannot dictate how civil law functions in other bodies of law. So my position is, while that editor's note is in there, I don't think the league has the authority to make that assertion under the UPOC.
Okay, and what were you citing UPOC for before I asked my question? I can't remember now.
So we enacted the UPOC, and that's our definition of sexual battery comes from the UPOC. Is that what you're asking?
Right. So you want to use UPOC for the definition, you've adopted it for that, but the notes you don't agree with.
I don't think that note has any bearing on KORA. I think this court has long held that KORA is as the Court of Appeals said it, it's a civil island in a sea of criminal procedure. I don't think that the league and the editor's note in the UPOC has any bearing on the enforceability of KORA itself. So while I understand that note is in there, I just don't think, I think it's wrong, quite frankly, and I don't think it's applicable to individuals who are convicted of sexual battery.
And going to what Appellant's Counsel said about ambiguity, tell me a little bit about the history of whether or not these municipal convictions would be included in KORA, specifically this House Bill 2568 in 2012 that Counsel mentioned.
I'm sorry for interrupting you.
Yeah, fine.
So when I look at House Bill 2568, to me, all that really changed in KORA was that we added juvenile adjudications and we changed when KORA obligations were given to defendants. And while all of that matters, I think really what we need to be focusing on is the plain language of the statute as we have it today and as KORA was when Mr. Adem was convicted of sexual battery. I think if we just look at the plain language of the KORA statute, I think that should dictate when it applies and when it doesn't apply. I think legislatures can draft bills to say whatever they want to say, and just because it's in one version of a bill and it's taken out in another, I don't think we can infer why they took municipal courts out. I would argue that they took municipal courts out because it was repetitive of what the statute said. It's repetitive of B5 in that someone who's convicted of a municipal ordinance should have to register. It says it in B5, and then in B7, municipal court convictions are a comparable offense to a district court conviction. So perhaps they took out municipal courts from that bill because they felt it was repetitive. I don't know.
Did you look at the testimony from the Kansas Association of Defense Counsel? Because it pretty much makes clear what happened.
No, Your Honor, I'm sorry. I did not have the chance to read that.
That's fine. Thank you.
Sure.
Much of your argument seems to be based upon legislative silence, but doesn't 222102 require affirmative inclusion of municipal courts for municipal courts to be a part of any provision in Chapter 22?
I think it does, but again, I think that necessitates that KORA registration is a part of a defendant's sentence. And I think this court has a long history of holding that KORA registration is not a part of a defendant's sentence. And I would also, whether or not it's a strong argument for me or not, I would say that both B5 and B7 authorize municipal court convictions to trigger CORA registration. While it's not explicitly listed in CORA, I think that there are times that CORA tells us that it's intended to apply to things other than state statute convictions. I think B5, if it was intended to only have applicability to a state statute violation, I think it would have said someone who is convicted of sexual battery pursuant to. So I think CORA realizes that there are times beyond a district court conviction for sexual battery when that would trigger registration.
Counsel,
Oh, go ahead.
sorry. I would just ask you the same question I asked your opposing counsel, which is, in your view, in this case, has CORA even been applied to a municipal court proceeding?
I think it has been applied to a municipal court conviction. If we want to include a conviction as a part of a proceeding, then yes. But I would say that CORA has been triggered from a municipal court conviction. If that answers your question.
Thank you.
Sure.
And I was going to ask, this is what you do. I mean, you're a municipal prosecutor, right?
Yes, ma'am.
Okay, so is this something that happens a lot?
I can tell you, in my almost 5 years of being here at the city of Shawnee, this has been the first sexual battery case that I have tried in municipal court.
Okay, but I mean, have people pled to sexual? You've never seen anybody plead to sexual battery, or?
No, Your Honor. And I think that brings up an interesting point and a kind of hypothetical I want to pose to this court. So say somebody in, let's say, Garden City commits the same acts as our appellant in this case, and say that city attorney calls the county attorney in Finney County and says, you know what, can you take this case for me? I don't have the resources to prosecute this sexual battery. The Finney County attorney says, sure, you know what, we'll take that case, we'll try it. That individual has a jury trial in front of a panel of 6 of his or her peers, in front of a district court judge in a district court room, and is convicted and has the duty to register. Yet someone who is in municipal court here in Shawnee, say, for example, I call the district attorney in Johnson County and say, can you prosecute this case for me? And the district attorney says, our resources are scarce. We can't take that case for you. I say, you know what? That's fine. I have UPOC here. I'll prosecute it here in municipal court. He's prosecuting municipal court, appeals it. We have a trial de novo in district court, have a jury trial, 6 of his peers, district courtroom, a district court judge. He's convicted and he doesn't have to register. That's not equity in our justice system. We're saying that 2 people who are convicted more or less in the same courtroom, more or less of a jury of 6 of their own peers with the same exact conviction, are treated differently under CORA.
Counsel?
They're both municipal court convictions, right? Municipal ordinance.
No. So the one in Finney County, if the county attorney's office tries it, then it would be a district court state statute violation.
Counsel?
Yes, ma'am.
Your example is interesting, but it presumes a lot. Since we don't have a record in municipal court, we don't know that in front of the municipal judge, the judge looks at the defendant and says something like, well, you don't want to fight this, do you? In district court, we do have a record and we would be able to look at what happened. What effect does that have?
I think that assumes that we treat municipal court convictions differently than we treat district court convictions. And while Mr. Klein brings up the argument that municipal court judges don't have to be attorneys, it used to be, and I don't know if this is still the case, that even magistrate judges didn't have to be attorneys. While in Johnson County, we do have attorneys, but just because they're not attorneys or aren't licensed under the law doesn't mean that they aren't acting within the scope of the law. I don't think that there has been a holding either from this court or from any other courts in the state that say there needs to be a court of record to necessitate a CORA triggering my phone is ringing. Triggering Cora to spring into action. I don't think that that's a requirement under Cora. And I think that there are several times under the Kansas criminal code that we treat municipal court convictions the exact same way as district court convictions. If we think in terms of thefts, 2 or prior thefts with a specific dollar amount, that triggers a felony. 2 or more convictions for possession of marijuana, that triggers a felony possession of marijuana. And in the bigger scheme, in criminal histories, municipal court convictions are always counted. I think with the one exception of code violations, municipal court convictions are always counted. So I'm not sure why we would apply them in criminal history purposes, but we wouldn't let Cora apply to municipal court convictions. So I guess, Justice Wilson, my response to that is we've always consistently had municipal court convictions that are comparable and that have as much weight as a district court conviction. And so I don't think that Cora necessitates that we treat them differently. Does that answer your question?
Yes, thank you.
Okay, sure. And I guess moving on to I've talked a little bit about why I believe B7 applies in talking about how municipal court convictions are comparable to state statute district court convictions. And I think that Cora opens that door to say, we understand that there are times beyond state statute convictions and even out-of-state convictions that there's another route where there would be convictions where Cora is triggered. And if it's not triggered by a district court conviction, a state statute conviction, and it's not triggered by an out-of-state conviction, what is that comparable offense? When would there be a time that there's a comparable offense if it's not a state statute violation or it's not an out-of-state violation? And I would submit to this court that that's a municipal court conviction.
And for that comparability, you would look 2 elements of the 2 offenses.
Correct.
All offenses, and look only at elements, not at, for example, procedural due process guarantees like a jury trial or court of record or anything of that nature.
Correct, Judge. But I would also argue that procedurally, in a municipal court, they're getting all of the same procedural rights that they would get in a district court, except that it's a court of record. But they also have the opportunity to have that court of record when they appeal their municipal court conviction. So I don't think that there are any procedural due process violations when we're in municipal court.
Do you think there's which do you prefer, the B5 or the B7 argument? And I'm not trying to make you Sophie's choice here. I'm just, which do you think is the stronger one?
To be honest, I think B5 is the stronger argument because the appellant was convicted of sexual battery as defined in KSA 215505A. I think when you get into comparability, then you get to look below the surface of the conviction. B5 looks at conviction alone. And because there is no definition for conviction in Cora, we have to use the plain language definition of conviction. And I would submit to this court that a municipal court conviction is equivalent to a district court conviction. Are there any more questions? I see I've run out of time. Do you mind if I wrap it up right quick?
You're welcome to do that. Thank you, counsel.
Thank you. Based on my argument that I believe there are 3 times within Cora where Cora specifically authorizes registration from a municipal court conviction, I would request that this court affirm the Court of Appeals decision and affirm Mr. Adem's requirement to register as a sex offender. Thank you.
Thank you. Mr. Klein, you reserve 3 minutes for rebuttal.
Thank you, Your Honor. I'll start with, I think that KSA 2102, forbids Cora from applying. And I don't buy the state's argument. The state is basically saying that silence is consent because the legislator didn't have didn't expressly say, municipal convictions, don't count for Cora, then it's got to be okay. And look, the other parts of the law that we're talking about, when the state says, hey, thefts, marijuana convictions, and counting it for sentencing and criminal history, I mean, that's all done because there are statutes that specifically say that that's how it's handled. In this case, I do not believe the legislator intended for municipal convictions to require registration. I did talk to the person who testified in 2012, so I understand the legislative history. I know the legislator didn't intend it. I don't think the law is clear now, and I don't think we can use silence as consent for Cora. And because of that, I think that the Court of Appeals decision should be reversed, and that Mr. Adem should not be required to register, nor any other defendants who are convicted of municipal convictions for sex offenses.
Run past me one more time. I don't care about legislative intent for purposes of my question. I just want to know from a plain language standpoint why 4902B5 doesn't answer this question.
I think because, unlike the city, I think that municipal convictions are not equivalent to district court convictions. They just aren't. And for all the reasons I argued earlier, I do think the Uniform Public Offense Code is pretty clear. The city adopted it, and they should follow that. And there's a reason the legislative note is in there. It's because these convictions are not the same.
Any other questions? Mr. Klein, do you want to summarize?
Judge, just briefly, again, I don't think these convictions are the same. I don't believe the legislator intended municipal convictions to require registration, and I believe the court should reverse the Court of Appeals and reverse the district court's order requiring Mr. Adem to register as a sex offender. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement, and we will be in recess until 1:30 this afternoon.